As Judge Reyes just put it in a new order, it is a cruel twist of fate that those people, transgender Americans serving in the military, who are protecting our constitutional way of life, are having their own rights denied by Pete Hegseth and Donald Trump, trying to take away their equal protection under the law and banning them from serving valiantly in the military, with the new transgender ban now overturned by Judge Reyes. I'm Michael Popok. This is important. You're on Legal AF. We had a case that was filed by 6 transgender soldiers led by Nicholas Talbot. They collectively have over 130 years of service to our country, putting themselves in harm's way, willing to make the ultimate sacrifice. But 7 days in office and 30 days in office for Pete Hegseth, respectively, Trump and Hegseth, they decided transgender people had to go, that they undermine military readiness, despite the fact that President Obama and his military thought they were fine. Biden and his military officers thought they were fine. And a series of experts that are supportive of these 6 as a class, all experts inside the government, inside the military, on military readiness, said that any suggestion that transgender soldiers are not militarily ready or undermine military readiness is a lie. Judge Reyes has issued her preliminary injunction in 79 pages. I'm going to read to you from the most important sections of the order. But the takeaway is, and I'm not shocked by this, I covered the hearing here on Legal AF about a week ago, where she excoriated, or as I said, she ripped the Department of Defense, Pete Hegseth, and the Department of Justice lawyer a new one. That's a legal term during the hearing. First of all, the lawyer was ill prepared in her courtroom, had not read the quote unquote studies that backed the Hegseth new policy or the basis for it, didn't know any of the basic facts. And that allowed the judge to just kind of blow him out of the courtroom. But now we've got the 79-page order. It is an injunction. It is a preliminary injunction. She is determined that it is more likely than not, the likelihood of success on the merits, that this group of transgender soldiers are going to win, to show that their Fifth Amendment rights of due process rights have been violated, their equal protection rights have been violated, and that all of the arguments by Pete Hegseth that, in effect, people who are transgender are liars, are deceitful, are dishonest, and undermine military readiness is nothing more than perverse animus and bias that has no place in the American way of life or the American Constitution. Let me read to you from the memorandum opinion. It says that the president has the power, this is on page 1, indeed the obligation, to ensure military readiness. At times, however, leaders have used concern for military readiness to deny marginalized persons the privilege of serving. Fill in the blank is not fully capable and will hinder combat effectiveness. Fill in the blank will disrupt unit cohesion and so diminish military effectiveness. Allowing fill in the blank to serve will undermine training, make it impossible to recruit successfully, and disrupt military order. Sound familiar? This is all the things Pete Hegseth was saying. First, minorities, then women in combat, then gays filled in that blank. Today, however, our military is stronger and our nation is safer for the millions of such blanks and all other persons who serve. Currently before the court is plaintiffs' renewed application for preliminary injunction. Plaintiffs who are transgender are being treated as today's fill-in-the-blank group by the Hegseth policy. Seeking nothing more than to serve their country, they asked the court to enjoin the military ban. They claim that the Hegseth policy were rushed and reached a preordained result, contains no analysis, and has an exception in name only. The ban at bottom invokes derogatory language to target a vulnerable group in violation of the Fifth Amendment. Not at all, the judge wrote, says the defendants, the Trump administration. They assert that the military ban is necessary because transgender people undermine military readiness and disrupt unit cohesion, good order, and discipline. Being transgender is inconsistent with high standards for service member readiness, lethality, cohesion, honesty, humility, uniformity, and integrity. Hegseth policy at 3. Gender ideology activists are unconcerned with the requirements of military service like physical and mental health, selflessness, and unit cohesion. Transgender persons, according to the Trump administration, cannot maintain an honorable, truthful, and disciplined lifestyle. Their expression of sexual identity is inconsistent with humility and selflessness. They also cost too much. Plaintiffs beg to differ, the court continues, and differ they can. Together, they have provided over 130 years of military service, the judge wrote on page 3. They have served in roles ranging from senior military science instructor to artillery platoon commander to intelligence analyst to satellite operator to operations research analyst to naval flight officer to weapons officer. They've been deployed around the globe from Afghanistan to Poland to Korea to Iraq to Kuwait to the USS Ronald Reagan and USS George W. Bush. One is presently deployed to an active combat zone. They've earned more than 80 commendations, including a Bronze Star, 2 Global War on Terrorism Service Medals, 2 Global War on Terrorism Expeditionary Medals, numerous Meritorious Service Medals, numerous Commendation Medals, Air and Space Outstanding Unit Awards, and the Military Outstanding Volunteer Service Medal, among many others. Defendants, the Trump administration, rejoin that these service records are inopposite. They must be ignored, and the court must instead defer to the military's judgment. The president issued that order 7 days after taking office, and Hegseth 30 days later. There is no evidence, the judge observed, that they consulted with uniformed military leaders before doing so. Neither document contains any analysis or any data. They pronounced the transgender persons are not honorable, truthful, or disciplined. But the defense counsel, during the hearing, concedes that these assertions are pure conjecture. The court, in saying that transgender people or people with gender dysphoria, that their inherent identity is inconsistent with a commitment to be honorable, truthful, and disciplined lifestyle, is that demeaning to them? Defense counsel, I don't have a characterization for that, Your Honor. Okay, and if I asked you about all the other words in the military ban with respect to characterization of transgender people or people with gender dysphoria, you would have the same answer? Yes, Your Honor. There's nothing supporting these assertions in the studies, right? That says those same things? No, Your Honor, not that I know of. No study, the court said, says anything close to those things, correct? Defense counsel, not that I know of, Your Honor. Okay. Transgender persons have served openly since 2021, the court continued on page 4, but defendants have not analyzed their service. That is unfortunate. Plaintiff's service records alone stand for the proposition that transgender people can have the warrior ethos, physical and mental health, selflessness, honor, integrity, and discipline to ensure military excellence. Defendants agree. They agree that plaintiffs are mentally and physically fit to serve, have served honorably, and have satisfied the rigorous standards. They have acknowledged that they have made America safer. So why discharge them and other decorated soldiers? Crickets from defendants on these key questions. This is the judge on page 5. Indeed, the cruel irony is that thousands of transgender service members have sacrificed, some risking their lives, to ensure that others have the equal protection rights the military ban seeks to deny them. This is powerful stuff. She then went through in her order the flip-flopping among the administrations about the transgender ban. Transgender soldiers can serve. Obama. Transgender soldiers can't serve. Trump won. Transgender soldiers can serve. Biden. Transgender soldiers can't serve. Trump. Just to show how ridiculous and ludicrous this attack on this disadvantaged group is, who all they want to do is be in the military and serve. Can we say that? Look in your own household. Are there many people that want to sign up now and be in the military for Donald Trump? These people continue to want to be. And then the judge went through all of the expert opinions obtained by the plaintiffs, all the people who have been in positions of trying to get the troops ready in senior leadership positions in the military. And every one of them said transgender soldiers serve honorably and admirably and don't detract from troop readiness or military readiness in the least. They are indistinguishable from their binary gender colleagues. I guess that's one way to put it. Here's what the judge says on page 31 of the brief, which I also thought was poignant, or to the point. The Hegseth policy banning transgender troops also does not contain 1, evidence that transgender persons are inherently unfit to serve. 2, evidence that being transgender is inconsistent with honesty, humility, or integrity. Evidence that being transgender conflicts with a soldier's commitment to an honorable, truthful, and disciplined lifestyle. 4, analysis of whether the cost of discharging and replacing transgender service members outweighs the cost of retaining them. 5, analysis of the effect on military readiness of losing thousands of service members, or among numerous other holes. 6, the criteria of exhibiting evidence of gender dysphoria, much less how such behavior will be policed. Defendants also concede they have had no evidence, assuming the court would even consider it, to justify the military ban. Then the court went and said the obvious to everybody who's a thinking, independent adult, that the transgender ban violates the Constitution. Fifth Amendment right to due process before having property rights and other rights taken away from them, and equal protection under the law. And when the Trump administration says, you always need to defer to my military judgment as the commander-in-chief, the judge reminds the Department of Justice and the Trump administration that in 2018, in a case involving Trump versus Hawaii, involving the military ban, or the Muslim ban, even Chief Justice Roberts outlined the limits to the exercise of the commander-in-chief powers. This must have driven the Trump administration crazy to be reminded of that, because now they're arguing that a single judge, like Judge Reyes, can't issue an injunction to affect the commander-in-chief and his war powers, when that is exactly what is supposed to happen. In fact, as Judge Reyes cites to the Federalist Papers and James Madison for that particular point, she said, while I am not supposed to go beyond my limits of my jurisdiction, you as the president are not supposed to go beyond your powers either. And it's up for me to help keep you in your lane. Paraphrasing a quote from James Madison from the Federalist Papers. So what's going to happen next? The judge has already stayed this order, so it's not in effect, to give the Trump administration a couple of days to go run to the D.C. Circuit Court and try to take an appeal. So that's what's going to happen. By today or tomorrow, I'll be reporting on the appeal that's been taken from Judge Reyes' order and what has happened at the D.C. Court of Appeals. Depending upon the 3-judge panel that's assigned, I'm not sure it really matters. I think the Trump administration loses. I don't think they're going to continue the stay, which is what he'll ask the appellate court to do during the pendency of this particular, appeal. He'll probably, more likely than not, lose at the D.C. appellate court level. I'll know better when I see the judge line up and the makeup there. And then it's up to the United States Supreme Court to address yet another ban by Donald Trump of disadvantaged people. What are they going to do now? What's Roberts, Chief Justice Roberts, who just yesterday, in a sensational criticism of the president, hours after he attacked one of the federal judges that Boasberg knows well, by the way, one of the federal judges that Brett Kavanaugh roomed with at law school, Jeb Boasberg. Maybe they should have done the research before they attacked him with a calls for impeachment. And then the chief judge fired back and said, 200 years of precedent says you got a problem with a federal judge, you don't say impeachment, you say appeal. So we're going to see what Roberts is going to do when this case comes up on a fast track, right off the backs of that extraordinary, historic rebuke by a Supreme Court justice, Chief Justice of the head of the Article 2 branch, the presidency. I'll continue to follow it all right here on the Midas Touch Network and, of course, here on Legal AF, the YouTube channel. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok firm, fighting for your justice every step of the way.